economy, business, technology, the totality of what makes man is what we bring to you here on this sponge. We give you the information that you need, from business to economy to politics to technology, and that's what we do here on this sponge, from the beginning to the end, and that is why we are here. Keep watching this sponge from Ben Television. I am Tunde Alabi, your host. Welcome to Voice, coming to you live here from our studios. My name is Tunde Alabi, and it's a pleasure having you on the program today. Today on the program, Voice, where we'll take a look at issues around legal matters in the United Kingdom, such as immigration, property, investment, education, marriage, and inform our community about the right ways within the scope of the law to do what you are expected to do in the United Kingdom. Joining us in the program today is our issue guest, Jennifer Obaseki. Jennifer Obaseki is the principal partner at Obaseki Solicitors, based here in the United Kingdom, specifically in London. I will be taking a look at one germane issues around legal matters here in the United Kingdom. People put in applications, but quite a number of times people either put in the wrong application or they put in the right application, but there are errors in the applications, or they put in the wrong applications, yet they will say I have errors. Whichever way it goes, the Home Office is not interested as long as you do not file in the right application for the right purpose. Or you file in the right application, but you have the wrong information. What are implications and consequences of such errors? This is what we'll be taking a look at on the show today. Jennifer, our lead partner, senior partner of Obaseki Solicitors, here will be giving us more information about that. My guest, Jennifer. Jennifer, thank you for being part of the program today.
My pleasure.
A couple of times, people filing applications to the Home Office for several things. And the Home Office does have different forms for different purposes. But there are instances where the same purpose, but there are different forms for specific reason. Yeah. But people do make errors. Quickly run us through some of the errors people make, either in wrong application or right application but wrong information.
Okay, well, one of the most typical errors is using, I would say, the FLRO. Most people don't realize that if you're going to be basing your application on almost anything to do with human rights, then you really should be using the new FLR form that is there. In the past, there was one form called FLRO, but now there are many forms that go under that FLR category. So you need to know whether you are basing your application based on your human rights, whether it's based on a circumstance that's completely outside the rules, whether it's something that is, let's say, you're within the rules but you don't meet it 100%. So you have to realize that if you're not sure, number one, you can call the Home Office to ask which is the best form to make the application on. However, the Home Office themselves, their employees often do make mistakes. So one of the things that we always suggest is, if you cannot afford a lawyer, to send an email to the Home Office. They actually do get back to you. But if you are taking professional advice, then your solicitor or your immigration advisor should be able to look at your circumstance and decide which is the best form for your situation. If you're outside the rules, you've overstayed, whether you're inside the rules and you have an extension to make or a specific application, or if it's a straightforward renewal of an application, what the correct form will be, or if it's an application for indefinite leave to remain for settlement, whether you use an FLR form or a SET-O form, or one of the various other settlement forms. Each depends on the individual's specific circumstance, and not every case is the same. So just because Jide uses FLRO, it doesn't mean Bode has to use FLRO. One of them may have to use a different type of form, you know. So it's a situation where common mistakes are used with the forms. Many people use derivative rights applications when they shouldn't. So that's using the EA type of application. One of the main reasons that people use that application is because of lack of funds. And understandably, if you are in a situation where you don't have an income and funding may be difficult, then that might be the only option for you. But in most circumstances, people don't realize that if you use the derivative rights application, you might not be able to get benefits once it's concluded. So you've got to also think about not just your current situation, but what will happen once your leave to remain is granted, if it is granted. If you know that it's going to be difficult for you to get work, employment or housing afterwards, why do an application that will lead you automatically not to be entitled to benefits that will enable you to support yourself once you have your leave granted? Another error that people make is not being clear about their immigration history or missing out big chunks. And so, for example, if you have borne a different name in the past and you've been fingerprinted in that name, if you're making a new application, it's important that you make full disclosure about your history, because you'll be asked to do biometrics in most cases. And if you have lied about your name in the past, or you've made a mistake about conflicting information, let's say, not lied, but conflicting information with regards to your history, your personal details, and you don't put down, I'm also known as so-and-so, you may be seen as deliberately trying to deceive the immigration authorities. And not only that, it could add to a delay in your application, and you may be seen as trying to deliberately, yes, misrepresent your situation. So being clear about your situation now, being clear about your situation if you are granted leave to remain, so what you're aiming for, whether it's going to benefit you in the future, making sure you get your entitlement to benefits or entitlement to travel, or the length of leave that you really are after, and also thinking about being honest about your history, or how to present if there's conflicting history and information on your application or in your previous applications. It's very important.
Do you need legal advice? Do you need professional help at a reasonable cost? At Obaseki Solicitors, we have experts in property law, human rights, criminal litigation, immigration, civil litigation, family law, business law, landlord and tenant law, employment law, Sharia law. At Obaseki Solicitors, we can provide you with advice and assistance at all levels. We have over 100 years experience in serving our local communities, and we have a new maritime and international law department. We can help you. Book a free consultation today. Obaseki Solicitors, providing you with advice and assistance at all levels.
Here we do have, as a case study situation where a client goes to a solicitor and issues around applications are wrongly filed, either using the wrong application or putting in the wrong information. Who do we hold responsible? Should the Home Office turn down? Of course, when they do turn down such application, they'll give you a reason for refusing. Now, if the reason now is as a result of a use of wrong form,
what happens?
What happens?
All right. The Home Office may do one of three things. First of all, they may reject it and say this application is invalid for these reasons. Use the correct form. However, if you haven't put your application in well on time, and that is, think about putting it in weeks before your leave to remain expires, if you have a valid leave to remain. If you don't do that, then you have that chance of becoming an overstayer by the time the Home Office looks at it, realizes it's the wrong form, sends it back to you, gives you the correction. So, you have to always make sure that you make attempts to renew your leave to remain in good time because of things like this. So that's number one. There's the chance that the Home Office may return the application and say you've made a mistake. Secondly, the Home Office may actually process the application. So, for example, there are situations where you can ask the Home Office to look at your situation, even though you've got discretionary leave to remain, but consider you for indefinite leave to remain. And it's down to the caseworker. There are certain policies that the caseworker may have to look at to see whether that is possible and that is right. There is a level of discretion that the Home Office has, but they don't always exercise it flexibly or favourably. So you've got to be very sure that you have a chance rather than wasting a chance. So if you put in an application, for example, as I say, for indefinite leave to remain using, for example, an FLRO form, and you haven't been here for 20 years, it's going to be rejected. Or an FLRFP form, it's going to be rejected, because that is the one of the requirements for using that form for indefinite leave to remain. Now, in that situation, the Home Office may look at the application, consider it, process it, and then not give you what you expected. So you think, I'm applying for one thing, and then unfortunately you get another, because you've used the wrong form at the wrong time. So for an example I'll give you of some of the errors I've seen in practice of that is people who think that they can get indefinite leave to remain after 10 years or 14 years because they've been given wrong advice, and they filled out the FLRO form. The Home Office has turned around and said, you don't qualify for this, but we've looked at your situation and you've been refused. Or you don't qualify for this, and we've looked at your situation, but because of your situation, we've decided to give you discretionary leave. So there's an example of that. So the Home Office may look at your application, process it and reject it, or look at your application, process it and give you something they feel you are entitled to, so that the money's not wasted. The other thing is, the Home Office, if they process your application and you're refused, that's it. Even if you realise it's the wrong form, it's very difficult to get any form of refund from the Home Office. It's difficult, unless there's been a change in tariff, unless they acknowledge their own mistake. Very, very difficult to get a refund from the Home Office. But I must say, now, the reason why we've sort of decided to raise this as a topic is because of the cost of applications. As you well know, the applications are very, very expensive. And now that there's the NHS surcharge that you have to pay before they even look at your application.
Which one is NHS?
The NHS surcharge is a charge that has been levied for, it's basically £200 a year or so for every year you are granted leave to remain in the United Kingdom, which is not indefinite leave to remain. So now that they're processing applications for discretionary leave at 2.5 years, the NHS surcharge that you have to pay on top of that is £500.
Why?
Because you're going to be using NHS services and you're going to be living in the United Kingdom. So this additional charge that has come into place is very, very expensive.
Is this a new?
It came in April. Tax? It's an additional charge. Much like when the Home Office changed their fees, it's, you have to be abreast, as I say, you have to be abreast of these things, these changes. And the current fee for, let's say, this popular FLR form is £649 or so. And then on top of that, you have to pay the NHS surcharge. And they won't process the application unless they get the confirmation that that has been paid, and you pay it online. So it's very, very vital that given the cost of these applications, you get the right advice right from the beginning before you make any attempt.
Jennifer, let's still stay on this NHS fee.
Yes.
Most of my viewers will be looking at this and say, look, we did not know about this.
I know.
Or our solicitors did not tell us much about this NHS thing. So now, if you're granted, say, 2.5 years,
yes,
discretionary leave,
and you're now going to renew,
and
yes,
you're now going to renew,
yes,
for under 2.5 years,
yes.
So for each of the
each year,
you pay £200.
Basically, yes, and it's hitting many people unaware, because you budget for your application fee, your Home Office fee, your lawyer's fee if you're using one, and then to have this additional charge on top, it's actually very, very, let's say, burdening for some families, especially ones with children. So the only exemption that you can think of applying for is if you're destitute. If you're homeless, you can apply for the fee waiver, and I've said this before on this program. So if you're being assisted by social services and you're in a situation where you don't have an income and you're homeless and you can prove it, try your best to fill out the fee waiver application form and add your supporting documents.
Jennifer, you and I know that an average immigrant trying to seek leave to remain, the last thing he or she is thinking about is to talk about fee waiver. She wants to get her application done.
Indeed, but if they're suffering and if they're in a situation where they're in a prolonged situation of vulnerability, hardship, and the thing that's stopping them is the application fee itself, and they're homeless. You have to add that, and they're homeless, and they can prove their level of destitution and vulnerability, then yes, they should use the fee waiver application. Examples of this are women who are victims of domestic violence, or men who are victims of domestic violence and destitute on the street. Maybe they've been here for 20 years, had failed applications, but they have no ability to regularize their status. People like that do need to seek help either from a charity or social services or from a friend or church, who will then validate the fact that they're destitute so that they can try their best to be, let's say, accepted under the fee waiver, qualify for the fee waiver, in order to put in the application to regularize their status.
Should an application be refused or rejected, will the NHS fee be refunded?
Not at all.
Oh, it's not refundable.
You know, when you put in these applications, it's one of those situations where the only one that is refundable is really your appeal fee if you win your appeal. The £140, if you're given an in-country right of appeal and you then lodge your appeal at the court, you have to pay a fee of £140 per person. So if you and your 3 children are refused, 140 times 3, you know, as well as your application times 3 and your NHS surcharge times 3. So, you know, I didn't see the Chancellor quoting in the budget how much these immigration applications are making the economy. But basically what I'm trying to say is the judge has the right to order the refund of the appeal fee. There is no refund, obviously, of application fees once an application is considered and refused, unfortunately. Also, if you get to the first tier tribunal, you're refused, then second tier, upper tribunal, and you've appealed, let's say, the first judge because he's made an error in law, because that's the only real ground that you can really go up to the upper tribunal. At the upper tribunal, they can order costs, but they rarely do. What tends to happen is, even if the Home Office acknowledge at that stage, okay, we've made a mistake, we forgot to consider this element of your case or that element, unfortunately, many of the times they say, withdraw your case and agree to no order as to costs. By that time, the family's paid the application fee, the appeal fee, the solicitors, and usually it's in the thousands. So we always try to make a policy of arguing our costs at that stage. But, you know, the judges are, it depends on the level of error by the Home Office. Most of the judges are like, well, it's being withdrawn. They're going to look at it again. The correct thing is for me not to make any order as to costs. But by that time, I'm usually quite passionate about this because I know the extent to which families have to borrow and look for money to try and pay for the expert advice that they're given. So I'm quite passionate about pursuing my costs at that stage. However, it's different if you have a judicial review, which is actually at the High Court, or even have a matter that goes on to the Supreme Court. Decisions about costs at that stage are usually rock solid, and if you are successful in your application, then you will usually get your costs without any issue. But pursuing your costs at the upper tribunal, I would always argue in favour of it. Most clients are scared. Oh no, just withdraw it. They've said they're going to look at it again. Don't let them get angry. Whereas the situation is they've made an error in law. You've expended so much to get good legal advice, so you should try to always claim your costs.
Okay. All right, try to always claim your... But the basic thing here that we're looking at today is errors in forms and applications. So if you are looking at putting in an application, make sure you use the correct form, the appropriate form, and make sure you fill in the right information. Two basic things now, using the appropriate form and the wrong information.
The wrong information thing is quite upsetting because sometimes the previous lawyer or previous advisor has made an error, a fundamental error in your name, in your address, or in your age, and correspondence has gone to the wrong address. Think about it, maybe the Home Office says, we've been writing to you at such and such address, and it's the wrong address. Can you imagine? Sometimes your name not down in the right way, or again, date of birth. But sometimes clients think that if they can change their details, because they've had a failed application in the past, they might get through on this new personal information. That's deception, number one. And number two, you're going to do your biometrics, so your fingerprints will not change, So if you've done fingerprints in the past under one name and you're going to do fingerprints again under another name, you're going to get yourself caught out and actually be labeled as somebody who has tried to use deception to, extend your stay in the country. And you have to be very careful with that, because if you do that type of thing, any other application may automatically be refused. You may also be prosecuted because it's an offence to make misrepresentations or even collaborate with another. So even if your advisor is advising you and helping you present false information, both of you could be in the most serious trouble.
Okay, all right. It's been a pleasure having you on the program today, Jennifer. We've been taking a look at issues of the use of the appropriate and correct form and filling in appropriate information so that you don't get refused or you don't get your form returned or whatever it is. So in doing that, you've got to look for competent, most up-to-date solicitors, as Jennifer has spotted. If you do require more information, you can go online and check more information on solicitors. You can contact Jennifer Obaseki on the number that's on the screen for more information, for personal contact and advice. This is how we can go on the program today. My name is Tunde Alabi. Jennifer, thank you for being part of the program.
Thank you for having us.
All right, until we come your way again, stay away or stay out of trouble. Thank you.
Are you planning a trip to Lagos anytime soon? Then make it a date with us at Dreamland Luxury Suites. Dreamland Luxury Suites is an icon in the city of Lagos, offering luxury at its most resplendent. Our executive rooms are fitted with classic Italian sofa seats, providing a truly comfortable stay away from home. We are located just 10 minutes away from the international airport in Lagos. Our facility is a perfect match to accommodate visitors. Enjoy the best of African and continental dishes. Experience fullness of hospitality like never before in an atmosphere of imperial splendor at affordable rate. Dreamland Luxury Suites. Luxury with comfort and privacy is our promise.
I say and do.
Economy, business, technology, the totality of what makes man is what we bring to you here on this sponge. We give you the information that you need, from business to economy to politics to technology, and that's all we do here on this sponge, from the beginning to the end, and that is why we are here. Keep watching this sponge from Ben Television.